Um, good afternoon for those who are in the Middle East, and good evening for those in North America, and perhaps there's a few people who I can say good morning to as well. Sorry, it should be good morning for the North Americans, I think, and rather good evening for people further east to us. So welcome to this seminar on defence contractors, or for defence contractors in the Middle East. We have a panel of partners from the offices of Al Tamimi. For those of you who do not know us, we're considered the premier Middle Eastern firm with offices now in 10 jurisdictions. Our latest jurisdiction being added is Morocco. So we not only have a wide variation of countries that we cover, but time zones as well now. We are going to have speakers from Qatar, the UAE, Saudi Arabia, Iraq, and also some regional discussions as well. Unfortunately, the scheduled speaker for Egypt was unavoidably called away to something else. So we will have to leave off the discussions that we had planned for Egypt. But if anybody has any particular concerns about Egypt, then they're more than welcome to address some questions to us here, and we will try and get somebody from the Egypt office to come back to you with the responses to those questions. We will have speakers from different countries, and after the speakers, we'll have a question and answer session. We are very cognizant of the fact that people may wish to keep their identity secret. So any questions can be posed by clicking on the Q&A button and posing a question, and the identity of the person requesting the request or posing a question will only be available to the Tamimi team. It will not be available to other participants in this webinar. So with that background and a welcome to all of you, I'll kick off with discussions about Qatar. I'm the partner in charge of the corporate commercial team in the Doha office of Al Tamimi, and speaking with me will be my partner Akbar Jafir, who is the partner in charge of the corporate structuring team. In Qatar, we probably have, and you can go to the first slide, please. Qatar, we have a law that covers government procurement called the Auctions and Tenders Law. And for defence contractors, fortunately, all the provisions of that law will not be applied to contracts with the armed forces, because the armed forces are excluded from the provisions of that law, as are Qatar Petroleum and its subsidiaries, as well as the Qatar Investment Authority. So determinations on contracts with the armed forces are determined by policies within the armed forces. So there's no set law or legal guidance with which persons have to be have to comply with. So the armed forces, we have seen a number of armed forces contracts, and they are quite varied. They've entertained contracts being provided from the actual contractor themselves, which is not usually the case with contracts with government entities in Qatar. We've seen contracts that apply laws other than the Qatar laws. I've seen, for example, I've seen a contract that applied American law and arbitration to the agreement, which you would just not see with other government departments in Qatar. including Qatar Petroleum. There is a strong tendency here to choose Qatar law, more often than not Qatar courts as well, although in the last 4 to 5 years we've seen a widening of arbitration as a determination mechanism for disputes in Qatar. So for defence contractors, it's just a matter of what the particular tender or procurement process is as to what compliance is with that particular process. So there is not a major concern regarding particular public procurement laws for defence contractors in Qatar. In terms of supplying products into Qatar, defence products into Qatar, there's no tax on those. There's no withholding tax on sales of products into Qatar. But I'll leave the tax issues for my colleague Shiraz Khan, who will talk later about tax matters. In terms of servicing contracts. And there are very often cases where there's a contract for a supply of goods, but also a post-supply maintenance contract and servicing contract. Those contracts, if they are to be carried out in Qatar, will require a presence in Qatar, establishment of a permanent establishment in Qatar, and be subject to potential Qatar tax on payments for services. The process by which a defence contractor can set up in Qatar is somewhat varied now. It used to be a lot more complicated. If I can go to the next slide. The foreign capital investment law prior to 2019 required entities in Qatar to be 51% owned by Qataris and 49% owned by foreigners. Law number 1 of 2019 relaxed that in a significant manner, and I'll let my colleague Ahmed Jafir go into a bit more detail on that.
Ahmed, you're on mute.
Thank you so much, Frank. Yes, so as Frank has correctly mentioned, the Foreign Investment Law number 1 of 2019 has come up with a major change if we really compare it to the previous Foreign Investment Law, where previously the requirement was almost in every sector that you should have a Qatari partner in case you want to do business in Qatar. So a foreigner previously used to have a requirement of to have a Qatari partner, which they refer to as a sponsor, which is not really like, or in Arabic it's kafil, which is not really the correct legal term. It's actually a partner owning 51% of the shares. However, the new Foreign Investment Law has changed that requirement, and we can say now almost every single sector in Qatar, a foreign investor shall have the right to open either, again, an entity, a company, or through a branch where you can have a full control over all the ownership of the entity, and again, opening a bank account, sponsoring all of the employees, so you don't really need to have a partner, a Qatari partner, or a sponsor. Going back now to the sectors, as I've just mentioned, almost all of the sectors now are available for foreign investment, except, like I would say, a few sectors like insurance, banking. These would require a cabinet approval if a foreign investor is interested to have more than 49% of the shares. There will be also the agency that requires this to be done by Qatari national. In addition to that, there are some few sectors like construction where, again, this is not yet permitted for full foreign ownership. In relation to the options you may have, now the Foreign Investment Law usually governs the mainland operations, which is any company or any entity operating under the umbrella of the Ministry of Commerce and Industry. However, in addition to the mainland, there are other options. There is the Qatar Science and Technology Park. There is also the Qatar Financial Center. In addition to that, recently, the Free Zone, Qatar Free Zone Authority has been very active in trying to, as much as they can, promote investment in projects in Qatar. But again, the Free Zone, although I would say it's one of the maybe appropriate options, because you don't, for example, you don't have tax, so it's tax-free regime. However, the interest for the Free Zone Authority is those projects that are more of trading in regional and international markets and contributing to the economy and the diversity in the state of Qatar. Going back to the mainland, and as we've mentioned earlier, a foreign investor shall have the right to apply for 100% foreign ownership application. This is again an application that should be submitted to the relevant department at the Ministry of Commerce and Industry. There will be some requirements to provide a business plan to the ministry, and based on the business plan, the ministry may come and suggest a minimum capital requirement. And recently we've seen that either like for, it's between 2 to 3 million Qatari riyals. The investor will not be really required to deposit that in the bank account at the stage of applying for the full foreign ownership. However, once the company is established, there will be a requirement to open a bank account, deposit the capital, and once the commercial registration is obtained, then this is where the sole shareholder is free to again transfer the capital back to any other country or to use it in Qatar. In addition to the incorporation of a 100% fully owned company, there is the other option, which is, as you can see from the slide, it's the option which is relevant to projects with the government of Qatar. So if a foreign investment has been awarded a project with that is related to a government project, whether directly with the government or through a main contractor, this will permit the foreign investor the right to apply for a branch registration. However, that branch registration will only permit for the investor to execute the works related to the project. And in case there is any awarded contract that has been awarded to the foreign investor, this should be added under the commercial registration and also the trade license. It is usually the case if you have, for example, only an interest to come and execute one project, I would say the branch is the best option. However, if you have the interest to have more than a project, or maybe an interest to work with the private sector rather than the public sector, this is where we will say that the suggestion is to open or to apply for opening a company with full ownership. In addition to this, I've mentioned the Qatar Science and Technology Park. This is more of a research hub, so you're not allowed to do any, let's say, construction services or trading services. So if you need to do so, again, the mainland is the best option. In addition to that, there is the Qatar Financial Center, which I will leave for Frank to explain more about that option. Frank, you're muted.
Thank you, Ahmed. I think we can have the next slide too, I think. So the Qatar Financial Center was originally established as a center for the banking and insurance industry and for companies that serviced companies operating within the banking and insurance industries. And it's probably 7 or 8 years ago, they expanded that remit to allow consulting companies to come in, notwithstanding that they had nothing to do with the banking or insurance industries. And we've seen a major increase in the number of companies that have come in to the Qatar Financial Center, undertaking consulting activities, IT consulting, human resources consulting. There are lawyers and accountants. There are all sorts of professional businesses in the Qatar Financial Centre. The one aspect of the Qatar Financial Centre that has been used by defence contractors is the ability to establish management consulting office in which the Qatar Financial Centre entity provides services to other companies in its corporate group. So on that basis, a defence contractor may sell some hardware to the armed forces, and the company that sold the hardware may establish a management company within the Qatar Financial Centre, and that management company can have people on the ground. It's 100% owned by the foreign entity. There's no requirement for any levels of Qatari ownership, and they can assist the parent company with fulfilling its contractual obligations under its supply contract with the Defence Department. It's proved to be quite a useful mechanism where maybe 2 or 3 technical people need to be on the ground to be consulted from time to time. It will not allow the QFC company to import any product. That is done directly between the parent company and the armed forces, but it does allow professional and technical people to be located permanently on the ground in Qatar, as long as there's not an element of unskilled labour in terms of the employees. That entity is capable of performing in Qatar. Now, we did see for a while, we have an unusual situation in Qatar because we have a US base in Qatar, and there are contractors that do work for the US base. The branch office that Ahmed was talking about, based on government contracts, that it used to be the case that this was allowed to occur for contracts for the US base, and the Defence Department withdrew support for that concept. And so we saw a number of these entities establishing in the Qatar Financial Centre so that they could have some people on the ground as supporting the parent company that had the direct contract with the US base. So now that you can, through mainland Qatar, have 100% foreign-owned entity much more easily than previously was the case, it could well be the situation that people servicing the US base may look at that option for going forward for Qatar. From a Qatar viewpoint, that's probably the end of our discussion. My partners Ahmed Saleh and Richard Catling will be talking on matters for the UAE. Ahmed is a partner in the IP department, and Richard is a partner in the corporate commercial department. So I will throw to Ahmed to kick us off, and for the next slide to go ahead.
Thank you very much, Frank. Good morning, good afternoon, everyone. So I'm Ahmed Saleh. I am partner and head of innovation and patents at Al Tamimi, based in Dubai. There are many considerations to be taken into account by defense contractors while doing business in the UAE. We've selected some important considerations to be taken into account. This is not an exhaustive list by any means. It's just some important factors to be taken into account by defense contractors who wish to come and do business in the UAE, particularly with the government. So primarily, first of all, of course, it's important to for any defense contractor to take into account their own rules with respect to export control requirements by their governments and to get the required approvals. That's something which is important to note. The second consideration which we would like to discuss and expand a little bit on is the new UAE offset requirements, which is under the Tawazun Economic Program, TEP, and policy guidelines, which is there to ensure that the defense-related procurement by the governments results in industrial participation by the defense contractors. As we will see, there's a big focus by the government in the UAE on developing the local defense and security sector in terms of capabilities, in terms of supporting the local partners inside the country to build their capabilities, whether on the technology development side, creation side, or on the manufacturing side. We'll go through a little bit to provide an overview on these. However, of course, defense contractors are invited to consider these, of course, guidelines and policies with a lot of attention. And again, what we will provide is not exhaustive, it's just some key aspects which we find important to bring to your attention. And the last consideration take into account, which we are discussing here today, is for any patent registration which relate to military and defense, there is a requirement in the new industrial property law that the approval, the prior approval actually of the Ministry of Defense must be obtained in order for any applicant or any company to go and register the patent rights or other industrial property rights outside the country. And so when a patent applicant applies for a patent registration at the patent office in the UAE, the patent office will communicate with the Ministry of Defense in order to seek such an approval. And the Ministry of Defense can decide that the applicant should not go and register these industrial property rights outside the country for secrecy purposes. And as well, they can decide to keep or to require the applicant to keep this confidential for a certain period of time, which they will determine. And the applicant, of course, can here require some kind of compensation in exchange of these kind of restrictions, if it is the case. Next slide, please. Here are a couple of important aspects just to bring to the attention of defense contractors who are looking to do business with the government in the UAE. So first of all, it's important to meet to seek the government to seek government contracts by a foreign entity for these kind of regulations. So any defense contractor who wish to do business with the government needs to meet and to respect and comply with these TEP policy guidelines, provided, of course, certain provided they fall under these policies, and there are certain criteria which apply for a defense contractor to whether they fall under these policies, and they should respect these requirements. The main one is, first of all, the contract value. If the contract value is beyond 36,730,000 dirhams, in value. So if the defense contractor is looking to provide, for example, to contract with the government for a contract value which exceeds 36,730,000 dirhams, then they should look to respect these offset requirements under the new TEP, which was issued in 2019. And of course, there are certain obligations which need to be met, and the defense contractor actually will need to come up with a project and agree on with Tawazun, who is governing this program, and come up with an agreement for the implementation of a project inside the country, which ultimately will benefit the country in terms of certain areas of priority of focus that the government deemed important and which are listed and cited inside this policy. So an agreement must be signed with Tawazun in this respect, and the defense contractor must implement this project to generate offset credits, and there are criteria on how these credits can be allocated to the defense contractor. And overall, these credits should be equivalent to around 60% of the value of the supply contract. So if the supply contract, for example, is 100 million dirhams, these credits should be equivalent to around 60% of the overall value. And in terms of value, and there are certain project categories which are provided under the policy through which the defense contractor can go and implement the project. So the first one is investment, and the second one is contractual engagement, and the third one is capability development. We'll have a little bit a closer look into these three categories to give you an idea about these. Next slide, please. So the first category is investment, and under this category, it can take the form of a traditional equity joint venture with a local partner, or partnerships without equity, such as co-production of technology or the development of new technology. And as we can see, there's a big focus and emphasis in the policy on development of technology, new capabilities to the UAE. And this is, again, it goes to the spirit of developing the local capabilities inside the country. And the development or technology co-development require the development of a new technology in the UAE jointly with a local partner, which could be a government entity, a company, or an institute. Here, I would like to give to let my partner Richard Catling to a little bit comment on these kind of commercial arrangements and some of the local law requirements for these.
Thank you, Ahmad. So the Tawazun Economic Program Guidelines basically state that the defense contractor can choose between the different options in terms of the structure for the project, but obviously it's primarily going to be dictated by the project that they're tendering for and the suggested approach to engaging with the government or government affiliated entity. But ultimately, the different options really fall into two categories: that of a contractual arrangement or a corporate joint venture. And corporate joint ventures are obviously something that traditionally has been the route through which foreign investors and other parties have collaborated with local companies and government agencies due to the disparity between the expertise and technological contributions made by both the foreign partner and the local entity. The nature of the procurement laws means that whilst in recent years, liberalisation of foreign ownership and direct foreign ownership means that quite often in most industries it's possible for foreign ownership to be for foreign owners to hold a majority, if not all, of the equity in a venture. With regards to defence contracting, that remains that isn't the case, and so depending upon the particular government agency that the defence contractor is partnering with, it could be that a significant minority stake is available in any equity joint venture. With regards to how they would be established, that would nearly always need to be through a mainland company, so an onshore company in the UAE, i.e. outside of the free zones, which would be subject to the commercial companies law, which is ultimately a civil law that has been amended on a number of occasions, but ultimately does represent quite a straightforward and standard civil law approach to trading companies. But it is possible, and it is market practice, for shareholder agreements to be entered into in addition to the standard provisions in the memorandum of association of a company, and that whilst quite often the sort of international standard approach to shareholder agreements is not always fully implementable, basic and standard provisions relating to management of the company, as well as rights attaching to shares, are fully capable of being implemented in that shareholder agreement and enforceable. Again, with regards to this particular industry, it is likely that the shareholder agreement would need to be subject to local law, but the UAE being a party to the New York Convention, arbitration arrangements are capable of being introduced, though ultimately it does depend upon the negotiating powers of the parties to as to whether or not that's possible. With regards to contractual arrangements, again, the type of contractual joint venture profit share collaboration agreement that you're likely to see would in most instances mirror the standard international practice as it pertains to those sorts of arrangements, with the ability to include defined performance requirements, risk sharing mechanisms, and also profit share in a way that again would be fully binding and contractually enforceable. Ahmad, would you like to talk about work packages?
Thank you, Richard. As for the contractual engagement category, that's an important one among the three different types of projects which are listed, and this is actually focused and to aim developing the manufacturing capabilities inside the country. And actually this would comprise signing a work package contract with a local UAE supplier or manufacturer to manufacture these products in the UAE and export the products outside the UAE, or provide services to foreign buyers. So here, this is an important aspect to create supply opportunities for the local industry and develop these manufacturing capabilities and the exporting products outside the UAE. And the third category is capability development, which again goes to the core of the spirit of developing the technology and innovation capabilities inside the country, and basically the projects within this category requires the defense contractors to provide knowledge, technology, and or capabilities to local entities or UAE nationals. And this requires transferring process know-how, intellectual property, or training and development programs to a local entity. And the recipients of the knowledge or capability must be a local entity or UAE nationals. Next slide, please. Here, we've listed here some credits parameters, and as I mentioned, this project, which needs to be agreed on between the defense contractor and Tawazun, and be part of an agreement between them actually for implementation, needs to come up with credits. So the defense contractor needs to come up with credits, and as a fruit of the implementation of this project. And depending on, of course, the type of the project within these three categories we discussed, there are certain parameters among these listed here, which can or cannot apply to one or the other of the categories. So here, one of these credit parameters is the contribution in equity or cash, contribution in assets, which can be tangible assets, which can be equipment or hardware, for example. Contribution in intangible assets, which is very interesting, and that can be software, IP licenses, know-how, or training. Net income, salaries paid to UAE nationals to, of course, foster the local capabilities, work capabilities, and support the UAE nationals with work opportunities, contract value of the work package agreed between the UAE entity and the buyer, value of training and development programs they put on the table through the implementation of the project, the export revenues, if we're talking about developing or manufacturing the products in the UAE and exporting these outside. And finally, the value of the IP generated, which need to be a proven commercial value generated or developed by the project in the UAE. And it's important to mention here that the generated or developed IP would take into consideration, of course, the technology readiness. So it's important not to be only kind of theoretical kind of technology, which doesn't have yet technological application, but the readiness of the technology is taken into consideration for the allocation of these credits. And another important consideration, the UAE entity, meaning the local partner, must own at least 50% of the intellectual property. Next slide, please. And so I'll go back to Richard if he has anything to add on the corporate side.
No, I think in the interest of time, perhaps we should pass over to Graham, who can speak about KSA. Thank you.
Thank you.
Well, just to introduce Graham, Graham Nelson is a partner in the Saudi Arabia office. He's based in the Eastern Province in Al Khobar, but he's also worked in Riyadh and spent some time in our Jeddah office as well. So he's very familiar with all of our Saudi Arabia offices.
Thanks, Frank, for that very kind introduction, and I hope it's not misplaced. Good afternoon, good evening, good morning, and hopefully not good night to everyone who's tuned into this. Very happy to be with you today to talk about the Saudi Arabian aspects of the subject. Of necessity, given the time constraints we have, this is going to be a fairly brief overview. It's also, I think, of necessity going to be slightly discursive, because a lot of the subjects which are on that screen there, whilst I chose for the purposes of this seminar to identify them separately. In fact, some of them actually merge almost seamlessly together, because the same sorts of issues tend to recur. The starting point to the discussion, of course, is Saudi Arabia's interest in this sector, which is well known, and its appetite for investment in defense related matters has, if anything, increased, I believe, in the last 3 or 4 years, based upon my own experiences, our experiences, I should say, in Saudi Arabia, given additional momentum by the ongoing security concerns, but also in particular by the Saudi government's Vision 2030 program, which highlights defense as an area of particular interest to it in terms of achieving its overall end, which is to wean the economy away from its over-reliance on hydrocarbons as a source of revenue into other areas, which can result in additional employment, certainly in import substitution, and enhance Saudi Arabia's technology base. So defense ticks most, if not all, of the boxes as far as the Saudi government is concerned, which is why I think we've seen over the last 2 or 3 years a lot more interest in this area. The ambition, if most of you, I'm sure, are familiar with Saudi Vision 2030, so I'm not going to say too much about it, but the overall ambition is to localize over 50% of military equipment spending by 2030, which is a very ambitious objective, but nonetheless it's there. And the sort of developments which have occurred over the last 2 or 3 years tend to reinforce the fact that they being the government are quite keen on moving forward with that ambition. If we are a company that is interested in investing in Saudi Arabia in the defense sector in some way, and that can be actually by supplying direct, and we see a lot of that from places outside the country. Nothing wrong with that, and that happens all the time. Or by and this is to sort of give effect to what the Saudi government has in mind, establishing something in the country. What are the things which we need to have a think about? Well, the first thing, and this is really building block stuff, but nonetheless it is important because it is an issue which clearly exercises the minds of foreign clients in particular, and that is if I have a Saudi contract or a contract with an entity in Saudi Arabia, is it going to be enforceable? As I say, it's building block stuff, but nonetheless, if I was preparing a plan which related to an investment opportunity in this area, it's one of the things which I think I would be asking myself right at the start. The good news story is that subject to certain qualifications, Saudi Arabia contracts in Saudi Arabia are fully enforceable. In fact, I would stick my neck out and probably say, for most purposes, I'd have a higher degree of certainty and relaxation about the enforceability of contracts in Saudi Arabia than I would in many Western jurisdictions. Because a lot of and I have litigated or been involved in litigation in other countries, including, for instance, America and Australia. And I have to say, some of the things which can happen to you there, where out of left field an issue arises which completely derails a claim, are far less likely to occur in Saudi Arabia in practice. And when I am talking to our Saudi litigators here, they tell me what they're litigating about, and I ask myself the question, how's it going to turn out? I'd have a high degree of certainty about how it's going to turn out in a Saudi context than perhaps I would do in other jurisdictions. The qualifications relate to which are to some degree obvious. That is, if you have something in your contract which conflicts with Saudi law, and that for most purposes is Islamic Sharia, then it's not going to be enforceable. If it conflicts with Saudi policy, it's not going to be enforceable. But for the rest, it's really a case of, unless it's prohibited, it's going to be enforceable. So that's the good news story. And as I say, the parties are generally free to contract on whatever terms they want. There is a risk at the Saudi courts coming in over the top of the parties and deciding to interpret contracts in a way which might be slightly offbeat, not to say perverse, but that's that's always a risk with the courts anywhere, but it's particularly a risk, of course, where you're in a jurisdiction which has no reliance or very little reliance on legal precedents, like Saudi Arabia. In practice, I mean, we do see these perverse judgments, but in practice, we usually see that where there's a decision which is perverse, it is corrected on appeal, and the appeal process is a lot quicker than it would be in many other jurisdictions. The main, for most, it's interesting to listening to what Frank had to say about Qatar, because the main piece of legislation in Saudi Arabia, which any prospective foreign party dealing with, or any party dealing with a Saudi government entity has to contend with, is the Saudi government's procurements law. And unlike it seems Qatar, defense contracts are regulated by this law as much as any other contracts. The law regulates the way in which contracts have to be entered into, and contains a number of provisions which deal with the way in which they are to be applied. Now, the first thing to note is that as a general principle, governments with Saudi authorities, and that for many purposes is what we're talking about here, have to be entered into following a competitive tender process. However, there is a major carve out in relation to defense contracts, because there is a Saudi government entity called the General Authority of Military Industries, which is to all intents and purposes the gatekeeper in this area, and it can decide to exclude a particular contractual arrangement from that tender process, and in many cases, if not most cases, it would do so. However, the rest of the tenders and procurements law is applicable. So even though we may not have to go through a competitive tender process, we may find that other parts of that law might apply to our contract, and in some cases inconveniences, quite frankly. The GAMI, as well as hopefully excluding us from a competitive tender process, is also in charge of issuing various licenses and permits which would probably be required for, in fact almost certainly will be required for, any activity in this area, particularly if it involves an onshore presence. So that would include licenses for military manufacturing, licenses for providing military service, licenses for trading or military articles or services. So inevitably, we're going to have to deal with GAMI. There may also be requirements for additional permits. In fact, if we're talking about a foreign investor, there will be a requirement for a license under the foreign investment law. In practice, that has nothing like the horrors that it used to have. When I arrived in Saudi Arabia, when was that, 10 years ago, there was a foreign investment law, still is actually, but it might have, but I always thought that was a bit of a misnomer. It should have been more of a foreign disinvestment law, because it was so difficult to get foreign investment licenses. Things have come completely 180 degrees since then, and in fact, the getting the foreign investment licenses is by no means as arduous as it once used to be, and provided GAMI is on side, I would expect a license to issue fairly quickly. There will also be a requirement for other licenses and permits, some which are licenses and permits which relate to just about any economic activity in Saudi Arabia, but in the context of an investment in this area, particularly where we're talking about a joint venture, there may well be a requirement for a competition law merger clearance. That in itself could be the subject of a webinar in its own right. I'm not going to go there, except that potentially, at least if there's a joint venture involved, the issue needs to be thought about. Hopefully a filing will not, or full filing may not be required, but maybe it will be. The other thing to do, the final point in relation to the government tenders and procurements law, and this is really a trap for young players, the in the law, there is a provision in there, it's Article 69, which says that the government agency and most, just about any alter ego of the Saudi government would be a government agency within the meaning of that law. They may increase the contract value by more than 10%, by no more than 10%, or decrease it by no more than 20%. So that's just something to watch out for as well. If we are establishing a presence in the country, then that's probably going to lead us in the direction of lead us to an LLC company, a Saudi LLC company, that is. And if we have to go that way, then if there is going to be Saudi investment, then there's going to have to be a shareholders agreement. At least I would expect that to be the case. Now, in relation to shareholders agreements, as I say, one of the first things that clients ask themselves is, well, is it worth the paper it's written on? Well, the answer is yes. But we then get into questions about whether particular provisions are going to be enforceable in Saudi Arabia. Now, as I said initially, the default position is that they will be enforceable. And as starting point of discussion, I tend to say to clients, look, if whatever works for you in your home jurisdictions, we start off with that here, and then we'll see how we go. Now, there are, and generally speaking, that works. However, there are some areas where it will not work, or it works with difficulty. The first area where we have problems is in relation to call and put options, because as a matter of general comment, options are difficult to enforce in Saudi Arabia under Sharia because of the inherent certainty which attends those options themselves. That is, will the option ever arise? So that is a difficult one. On the one hand, you have Islamic Sharia, which says, well, actually, this could be a problem because of the uncertainty principle. Versus, on the other hand, we have the principle, which is, well, the parties agree to it, so it should be enforceable. How will it play out? It's difficult to say. The advice we tend to give to clients is be careful. Don't bet your house on it. However, if we are extremely prescriptive about those provisions, so there's so very little uncertainty about what's actually happening in practice, then we think that there's a good chance that they will be enforceable. The same general comment applies to drag along and tag along rights. For the same reason. It's Islamic Sharia. Should a party be forced to do something with its shareholding, at least in principle, that raises some serious questions. Does it stop people having those provisions in shareholders agreements? No, it doesn't. But it's just something you need to be aware of. However, the major issue in relation to shareholders agreements and in particular technology licenses agreements, which are usually part of the deal, or often part of the deal, in relation to investments in this sector, relates to dispute resolution. Now, it is not unusual for proposed investments to founder on the rocks of dispute resolution and governing law. And the reason for that is the starting point of the discussion is the government tenders and procurements law and the regulations which go with it, which say that any contract involving a Saudi government entity has to be a Saudi law governed process. And dispute resolution has to be in Saudi Arabia, and the starting point to that discussion is Saudi courts. Now, this is where clients really start to get nervous for reasons which I'm sure you'll readily understand, because there is a heightened level of nervousness about dispute resolution in Saudi Arabia. Part of the problems tend to be, and quite frankly, the biggest problem I think in practice tends to be around case management, and that is even simple cases can roll on and roll on and roll on. If you're talking about a dispute which involves the interpretation of what could be complex contractual rights and obligations, your timeline could be extremely long indeed. As a general comment, I find it very rare that contractual disputes, when they go through the courts in less than 2 years. Our litigators will tell you that it's possible to do it a lot quicker. I have to tell you, in practice, I've seldom seen it happen. So that's the first thing. Now, in relation to shareholders' agreements, I have to tell you my own particular view on that is that in fact maybe the position is far less serious, or potentially serious, than people tend to think it is. Why is that? Well, we're talking about how we organize and run a Saudi company, and it will be a Saudi company. Now, I happen to think that it makes sense for a lot of that to be subject to Saudi law, simply because it's a Saudi company anyway, and the Saudi company's law will apply to it. So, you know, if we're trying to regulate the operation of that company under some foreign law, I think that's going to be difficult. But secondly, and this is also a question I tend to pose to clients, and that is, just ask yourself one question. And that is, do we think that we're likely to want to enforce this contract, or are we concerned it's going to be enforced against us? Now, most clients tend to be concerned about money. In fact, all clients are concerned about money. In relation to foreign parties, it is, am I going to get paid? Is the money which is due to me going to be paid? And whilst it's a bit of a decision tree, I would say that probably for the most part, you're better off with a Saudi law governed contract, because it's going to be easier to enforce and quite easier to obtain a judgment on. And secondly, and most importantly, it's going to be easier to enforce in Saudi Arabia. So if your counterparty is a Saudi party with assets in Saudi Arabia, you're going to want to enforce it in Saudi Arabia. Okay, so that's the shareholders agreement. Yeah, there are some reservations about that, but nonetheless, it's not necessarily a deal breaker for the agreement, in my mind anyway, to be subject to governed by Saudi law, or with Saudi courts, if it comes to the Saudi courts being the arbiter in relation to disputes. However, I do draw a distinction in my own mind between agreements which relate to the operation of a company and other agreements which relate to technology. Now, why is that? And that is, well, for two reasons. First of all, if I was the owner of a very valuable technology, I would probably want, in fact, I certainly would want the highest level of certainty that my rights in relation to that technology are going to be as I expect them to be, if they were determined under a foreign system of law. And you know, you often will find that those rights, the exercise and enforcement of those rights is a well-trodden path, because legal precedence is applied, and so I have a high degree of confidence that if it's US, English, or Singaporean law or something else, that those rights will be respected. Problem with Saudi law is that it's a Sharia-based law, and in relation to technology, a lot of the concepts we're talking about are concepts which, according to Saudi law, would be esoteric. So it may be difficult to actually get the concept understood in Saudi Arabia. Impossible, no, but necessarily it could be difficult. And do I need that difficulty? No, I do not. So that's the first thing. But the second thing is that I really would not want to put my valuable technology at risk in any shape or form. And I do draw a distinction between arrangements relating to operation of a company versus arrangements relating to technology, where I'm just simply not prepared to negotiate on the basis where my rights in that technology could be compromised. And anecdotally, at least, I'm aware of a number of potential investments which have foundered because there was no resolution of that issue. There are provisions in the tenders and procurement law regulations, which admit the possibility of for non-Saudi law, non-Saudi dispute resolution process. The difficulty, however, is that if you want your absolute assurance about this, there is a simple answer, and that is you get an approval from the Minister of Finance. In practice, that's not going to happen. You won't get it. It'll take too long. And I when I was thinking about this last night, I can see why they're seldom, if ever, given. So you would have to think of some other way of avoiding the issue, because you certainly don't want your technology rights to be put at risk. This basically wraps up my comments in the time I have available. As I say, it's not the A to Z of the subject, but what I've tried to do is focus on those areas which in practice seem to cause most of the problems, and certainly the issues which tend to have a recurrence about them. I'd be happy to take any questions either now or later on or separately. So Frank, that's me done.
Okay, thanks, Graham. The next person to speak will be Mohammed Nouri from our Iraq office. Our Iraq office was established, I think, maybe 15, 16 years ago now. Mohammed's been there for a number of years himself. It's been an ever-expanding office, and it used to be managed out of the Qatar office many years ago, and then the Jordan office after that. But it's pretty much self-standing now with more than one office and a number of good operators. And I'll pass over to Mohammed, who's also in charge of the corporate commercial team in Baghdad, as well as being head of the office there as well.
Thank you, Frank. Good evening, good morning, everybody. Thank you very much for joining us. I think I will be very short. It may take with me 5 minutes to just address the main concern for the defense contract in Iraq. I would say at first that although the defense contract have been excluding from the governmental employment contract, however, the Iraqi court may apply the provision of this law whenever there is a dispute arising or before the court. We have seen that by ourselves whenever there is a dispute before the court. The main things is with the defense contract is whenever you have a contract in Iraq. So I would say the main and the best option for the company is definitely to have a branch in Iraq. And we have seen some of them, they have a limited liability company when the foreign investor can have 100% of Iraqi local company in Iraq. However, this law have been changed back in 2019 when a local partner should be hold the majority of the shares, and the non-Iraqi can only hold 49 of the shares of the limited liability company in Iraq. Having said that, will take us to the main subject I need to address it today, which is whenever you have a branch in Iraq, definitely you need to execute your contract in Iraq. If the contract is supply contract, definitely there is no need for a branch or registration in Iraq. It's just a supply contract. But if there is a contract or long-term contract or contract with maintenance, then definitely you need to be compliant in terms of registration in Iraq, and this registration to be with the companies registered, and then to have a registration with the taxes authorities, and then the registration with the Ministry of Labor, which take us to the visa issue, which have been seen that our client have faced the issues with the visas. The good things, they make it easier from time to time. Now, even they are, the Iraqi government, they granted free visa for many countries in Iraq, including the European country or US or Canada or the permanent Security Council countries as well. The two main visas which should be granted to the defense contracts is the 1-year multi-entry visa or the 6-month. It's depend definitely on the length of the contract. If it's 1-year contract, then the company could apply for this visa, and if it's less than that, definitely they need to apply for 6-month multi-entry visa. This takes us to another things, which is the work permit, because according to the Iraqi law, Article 13 of the labor law, it is prohibited to employ any foreign employees without obtaining work permit from the Ministry of Labor and Social Security Affairs. If such act committed by this company, it will be subject to fine. Definitely, we have seen that some of companies who has contract does not apply for the work permit, in which they lead to especially now Ministry of Labor, represented by Pension and Social Security, which are responsible for providing the work permit, refer these companies to the court, and definitely the one who is responsible for these companies is the appointed general manager, and then he should be attended in person before the court, and the court, which we have seen, it's very aggressive in this subject. So they may either, the good things now, they are fine that the company if there is no work permit, but the bad things, this fine, the company should deal with the violation within 60 days. Otherwise, the manager of the company may face imprisonment in Iraq. The regulation for the work permit, it's difficult if you don't have a contract, but in your case, when you have a defense contract, definitely with support letter from, let's say, Ministry of Defense or other governmental sector, then you can apply for the work permit. The good things with the work permit is when you have a contract is to have your employee in Iraq, have their visa, multi-entry visa to Iraq. When they come to Iraq, within 30 days, you need to apply for the work permit for them to avoid a violation and to be comply with the Iraqi law. But as we said, in order to have this work permit, you need to have a registration with the Ministry of Labor, represented by Pension and Social Security, and you may face another issue, which is the ratio. And as per Iraqi law, that's whenever you have foreign or expat employees, you need to have at least 50 Iraqis, and this is another challenge with most of the defense companies working in Iraq, because their contracts is special contracts, and they are special expat to deal with the high technique or weapons or equipment need to be dealt by non-Iraqis, or even when it's not allowed even to Iraqi to be in this contract. And then the challenges is to meet this ratio, and we are in a way or another assisting most of our clients to either to reduce this ratio or to deal with it in a way to avoid non-compliance with the Iraqi law. These things as well, and like the things is, at the end of the day, now the Ministry of Labor, represented by Social Security, very aggressive, and they refer most of the companies to the court, in which at the end of the day, definitely the company which has contracted, they need to get the money. So the things we have seen now, according to the cabinet resolution, that you need to have a clearance from the Pension and Social Security in order to get paid and to have, especially the last payment, unless you have this, and unless you are compliant and how you have clearance from the Pension and Social Security, you will not get paid from the Iraqi government, in which definitely you need to be compliant, in which you need to have, according to the Iraqi law, in terms of visas and in terms of the work permit. Thank you very much, and I'm happy to for any queries either now or later.
Our final speaker will be Shiraz Khan from our tax team. We're very proud of our tax team in Qatar. It's the first tax team put in place by a local firm in Qatar and covers all 10 of our jurisdictions. Shiraz is the regional head of the team, and I'll hand over to him.
Thank you, Frank. Good morning, afternoon, and evening, everyone. I'm just going to give you a flavor of the tax considerations which are applicable to you in the Middle East. Of course, each of the jurisdictions in the Middle East are sovereign countries, and they have their own tax regimes. So in terms of specific tax implications for a particular country, you do have to look at the laws and regulations of the individual country. But there are some common themes and common considerations which run across the countries. I wanted to start with some of the common misconceptions which are applicable both to defense contractors and companies and generally foreigners, foreign businesses, multinationals coming and doing business in the region. There's often a misconception that, in the region, there's a lot of oil and gas riches. There's lots of free zones. There's no personal income tax. So there's very limited tax in the region. And therefore, sometimes in terms of operating in the region, there's a gap, between the operational side and in terms of compliance on the tax side. And quite often, contractors get caught with tax issues later on because they're simply unaware. So it's definitely a good idea to understand the tax implications of doing business in the region, in the particular countries, and whether you could do something more tax efficiently. In terms of the misconception, of course, there are taxes in the region. Outside the GCC, all the countries in the Middle East have tax. And in the GCC, 4 of the countries have had tax for quite some time. Saudi was the first in the GCC to introduce income tax on businesses in the 1950s. And then Kuwait and Qatar followed in the 50s, and then the UAE in the 1960s. Although the taxation in the UAE is limited to certain industries only. But things have changed and are changing. There's been a will from the GCC to expand its revenues away from hydrocarbons and to diversify the economy. And tax has been a major part of that. And in line with these aspirations and aims, the GCC have, as you would have seen or probably aware, have introduced new taxes. They tightened the taxes net as well. So in 2017, the UAE and Saudi initially introduced excise tax. VAT followed as well in 2018. Subsequently, Bahrain and Oman also introduced VAT. And whilst UAE and Bahrain have had limited taxes for certain industry sectors, the UAE has announced that it's going to introduce a federal corporate tax with effect from the 1st of June 2023. So things are changing and have been changing, and tax is a major part of the policy now in terms of generating revenue here. The UAE, before it introduced VAT and excise tax, it set up a federal tax authority to manage these taxes, enforce these taxes. Now, in terms of taxable presence, I suppose most of you are, either providing goods and selling equipment to ministries and governments in the region, and also in addition to that, providing services. Now, generally speaking, across the region, from what I've seen from my past experience, in most cases, the sale of the goods is structured, as if the sale takes place from overseas. And generally, in most of these countries, there should be no tax implications, because if you're selling the goods as a non-resident and you don't have any presence in the country, and the title of the goods transfers outside the country before customs clearance, then there should be no tax issues. Mostly the tax issues come into effect when it comes to services. Now, in terms of the implications of doing business in each individual country, it just depends on how you do business in the country. A lot of companies, they tend to establish a legal presence, so typically a company and a branch, and the implications will depend on where you set it up and if you're able to set it up. So for example, if you set up a company, a couple of the countries, including the UAE in the future, they tax companies which are established here, and Oman as well, on a worldwide basis. So if you're effectively, if you're a resident in the country, which is typically defined as being incorporated in the country or being centrally managed and controlled here, then you'd be taxed on your worldwide income in the country. Another thing to bear in mind if you have a company is that some of the countries, and typical examples are Qatar, Saudi, and Kuwait. If you have a company and typically you need a foreign shareholder, and obviously the rules are changing fast as we speak, and as everyone discussed earlier, because increasingly foreign ownership is being allowed depending on where you set up. But where you do have a local partner and you're required to have one, the taxation of the company will depend on the ownership. So in Qatar and Kuwait, the ownership, local ownership element, the profits attributable to that would be exempt. In Saudi, they'll be subject to zakah. And the portion which belongs to the foreign ownership, that will be subject to income tax in Saudi and Qatar and Kuwait. So there is a difference in terms of taxation when it comes to companies, and it depends on ownership in some countries. When it comes to a branch, and again, as Ahmed discussed earlier, there are some challenges in having a branch because sometimes you're required to have a contract with governments in Qatar. Typically, they're taxed in the same way as the company, at the same tax rates. So all the profits which are attributable to that branch. So unlike a company where if you have a worldwide taxation in UAE and Oman, all the income worldwide would be taxable. When it comes to a branch, only the profits attributable to the branch are taxable. You do have to be mindful, though, in some jurisdictions like Saudi Arabia, they have a force of attraction rule which seeks to tax profits of the company, head office profits, essentially. So if you have any profits at the head office level from that country, there may be scope to tax those profits under this force of attraction rule, which would mean that more than the profits of the branch are taxed inside the branch. I think the other thing to be wary of is that if you have a branch, there could be some other challenges as well, and I'll come on to them, especially in the form of a permanent establishment. Now, if you don't establish a legal presence or a company or branch, and you're doing business on the country, the tax considerations will vary. Some of the jurisdictions have a concept of permanent establishment. So Saudi, Oman, Qatar, Egypt, all these countries have a concept of permanent establishment. And the definition and the meaning is the same as the international meaning. So typically when you have a fixed place of business through which you're doing business in the country, certain things are deemed to be a permanent establishment. If you have a branch, for example, if you have an office, even if you don't have a fixed place of business, if you do business in the country through an agent, you could be considered to have a permanent establishment. And now the definition of permanent establishment in some countries like Saudi and Oman, for example, is a little bit wider, and the tax authorities typically deem you to have a permanent establishment if you have more than a 90-day presence in the country. Otherwise, internationally, it's usually 6 months. So it's a less period when it comes to, and if you have a permanent establishment, so you'll be taxed to the extent of that permanent establishment. And in Saudi, for example, the force of attraction rule will apply even to the permanent establishment. So you may have other profits of the head office which are generated from the country, and the tax authority may seek to tax those profits. The other thing to bear in mind is that, particularly in Saudi, if you have a permanent establishment, usually in most countries, you would file a return on a net profit basis. But in Saudi, if you have a permanent establishment and you don't have a branch on the ground, you haven't kept records on the ground, they'll seek to tax you on a deemed profit basis, which means that they ignore all your costs and they seek to tax you based on a percentage of the revenue. So that's something to be mindful of, and that could obviously result in a lot of additional tax exposure, which you weren't expecting. Now, if you don't have a permanent establishment in the country, again, it goes down to which country it is. There are some countries where you could be taxed and required to file a tax return in the country, even in the absence of a permanent establishment. So even if you spend 1 day in the country and you're providing services, you may be required to file a tax return. And that's usually jurisdictions where they don't have the permanent establishment concept, so you have no protection. And in addition to that, they don't have any withholding tax. So this is their way of enforcing the tax. You have to register and file tax returns. And an example of that is Kuwait. Now there's also withholding tax as well. So in a lot of the countries, where you don't have a permanent establishment and you generate local source income, and you may still be subject to tax if you provide services in the country or outside the country in certain circumstances. And the withholding tax rates could vary depending on the country. It's usually 5% up to 20% across the region. And some of the concepts in terms of different countries, they have a wide application for withholding tax. So in Qatar, for example, historically, until there was a recent change to the legislation in 2018, if you provided the services outside Qatar, they wouldn't be taxed in Qatar. But they recently changed the rules such that if you provide the services and the services are used, enjoyed, benefited from, and exploited inside Qatar, then withholding tax would still be applicable. Even in Saudi, it depends on the nature of the services. So for certain technical services, regardless of where the services are provided, you'll be subject to withholding tax in Saudi. And in the case of other services, if they're wholly provided outside Saudi, you may not be taxed. So it's a case of looking at, what kind of services you're providing and where you're providing them. Another important thing is, I think I mentioned earlier, the sale of goods shouldn't be taxed, and the services are. However, you need to think about this contractually, and you need to segregate the consideration so you could, ascertain what consideration is attributable to the goods and what consideration is attributable to the services. In the absence of that, you're leaving it to the tax authority's discretion to determine, what the value of the goods is and what the value of the services is. And the risk is that they may seek to subject the entire contract. So that's something that you have to bear in mind. When it comes to Kuwait, and it's the only jurisdiction, Qatar has a limited retention, which they're now applying, and they also had a similar system to Kuwait. But in Kuwait, there's no withholding tax. Instead of withholding tax, they have another system called tax retention. Now, under this tax retention system, it's similar to withholding tax, but it's not the same. It's not a tax, and that's why it's called a retention. So whoever is paying you, if your client pays you from Kuwait, they're required to retain 5% of the contract value until such time, if you're taxable, you provide them a tax clearance certificate or no objection letter, which is obtained if you go to the tax authority, you register, you file your tax returns, you pay your taxes. So you have to go through the whole compliance process in terms of obtaining this tax clearance certificate or no objection letter. I think the other thing you have to be conscious of, some of the countries, they have dual regimes. So, you may have a free zone. So you have to look at where you are. Like in Qatar, for example, you have the QFC. In Iraq, you have a dual regime. So you have the normal Iraq regime, and then you have a different tax regime, which is applicable in Kurdistan. They are quite similar. The regime in Kurdistan is based on the Iraq regime, except some of the rules are different. For example, there's no withholding tax. It's not enforced in practice. Now, some of the other taxes which are there, there is customs in all of the countries in the Middle East. In the GCC, there's a unified customs agreement. So there's a fairly similar regime applicable across the GCC. If you're importing goods, it's generally subject to customs of 5%. In Saudi recently, some of the rates were increased, and otherwise it depends on the nature of goods. Typically, it's 5%. It could be higher. Some goods could be exempt. There's also value-added tax. So I'm not sure if you're familiar with value-added tax. In the US, we have sales tax. It's a little bit different. Value-added tax is a tax which is applied on the supply of goods or services at each stage of the supply chain. So from production all the way to distribution, value-added taxes applies. And as a business, you're supposed to typically collect the tax on behalf of the government from your customer. And you're allowed to, if you've paid any value-added tax, you could claim a credit against a value-added tax you've collected and pay the difference over to the tax authority. So this is something that you have to be mindful of as well. And value-added tax is a consumption tax. Wherever the consumption of the goods or services takes place in the country, you have to actually you have to the supply will be subject to VAT. Now, if you're completely non-resident and the customer you're providing the goods or service to, they're registered for VAT, then in that case, they'll be required to account for VAT under the reverse charge mechanism if you have no presence, and you won't be required to account for the VAT. And typically that applies where the customer is not a business, which would happen if you're dealing with the government, for example. So under the government, they're not a business, but they're also not registered for VAT, but they do have a mechanism where they could claim credit. There's also transfer pricing rules across the region, and they're increasingly coming in. These were introduced in Saudi in 2019. In Qatar, they've been there even before that. Jordan has recently introduced them. And whilst in some of the other countries, there's no specific transfer pricing rules, the tax laws do have a concept, arm's length concept. And even in Saudi and Qatar and Oman, there was a concept of arm's length anyway. So if you have related party transactions, you have to generally ensure that the value is the value which would be there if the parties were not related. And the tax authorities can adjust the value, the consideration. They could disregard the transaction, and they generally have wide powers. In terms of tax incentives, of course, I mentioned free zones. Some of the free zones, they have exemptions, tax holidays. So that's something that you have to be mindful of when you operate in the country. Can you go for a free zone, and you know what the tax implications will be? In the UAE, there will be special treatment for free zones as well, but it's not at an absolute. It's not at an absolute. You have to look at what your operations you're doing and how you're structuring them. And if you're doing business with the mainland and you're acting outside the scope of your license, then you could be taxed. In terms of customs as well, in some of the GCC countries and Iraq, if for military equipment, there is an exemption for customs, and in some cases it's mirrored for VAT purposes as well. Finally, I mean, I'm conscious we're running out of time, so I'll just touch on some of the practical considerations. In the region generally, as compared to the Western countries, in the Western countries, the tax legislation is very prescriptive. If I look at the UK, for example, and if I was to place all the legislation, you know, they call the yellow books, it'd probably come up to here. And if I add on top of that the case law, it'll probably be above the ceiling. In this region, the tax laws are generally quite brief. However, you're still dealing with the same level of complexity. So, you know, they're often quite vague, and that's why the tax authorities do a lot of things in practice. Sometimes it's based on a radical interpretation of the law. In other cases, it's based on an interpretation which is not in line with the law or international practice. So it may be something you're completely unfamiliar with, and the tax authorities issued you an assessment which you can't accept. There are statute of limitations. Generally speaking, across the region, it's around 5 years. It can be extended if you haven't filed a tax return or you're seeking to evade or avoid tax. But the good thing is, I mean, you have some protections, because even if the tax authorities issued an assessment, they do have a dispute process in all of these countries, which is fairly independent. And you know, so essentially you have to initially go to the tax authority and you have to ask them to review their decision on the assessment. If they reject your application, sometimes if you don't hear from them within a certain period of time, you could go to specialized tax committees like in Saudi, or otherwise just tax committees in Kuwait and Qatar, and then subsequently you could appeal to the courts. In Saudi, there's no longer an ability to appeal to the courts, so everything, the procedure is fairly independent, and you do have the right to challenge the decision of the tax authority. Quite often we face challenges where, you know, some of the clients, they haven't appealed on time, so they haven't fulfilled the requirements of the appeal, and in other cases the case is not so strong because they haven't planned well in advance. And sometimes the agreement doesn't document what they were actually trying to achieve, and since the agreement is the evidence of what they're doing, and sometimes the documentation is very important, keeping that audit trail and documentation in place. I think the other point to bear in mind is that, you know, in the GCC and generally across the Middle East, with the exception of Egypt, the US doesn't have tax treaties with any of these countries. So if you are looking to set up companies here, sometimes sometimes clients prefer to have, a shareholder in a jurisdiction where there's a double tax treaty, or structure the arrangement from a treaty jurisdiction. Of course, it has to be supported by underlying substance. And finally, in a lot of these countries, you do need to comply with your taxes, and you need to get tax clearances, and a lot of other things may depend on the tax clearances. For example, your continued registration, your ability to register your employees and to deal with immigration authorities. So tax clearance is very, very important. I think that's it. I think the time is up now. I'll hand you over to Frank.
So there have been some questions posed. A couple of them have been answered through the chat box, but I'll go over those very quickly. There was a question for Iraq as to whether Iraq is still subject to various defense-related sanctions. Mohammed has answered that no, and I don't know if Mohammed wants to add anything to that, or the word no is enough in that regard.
Yeah, I would say, thank you, Frank. I would say that all the sanctions on Iraq have been lifted from the Security Council, and now Iraq is free to contract in defense sector, and there is no any other sanction applied on Iraq. And even Iraq is now out of the Chapter 7 of the Security Council. Thank you.
Thanks, Mohammed. There was a question for the UAE regarding whether there are any restrictions in the mainland, or for a mainland entity to be 100% foreign owned in the defence sector. And Richard had answered that there were still restrictions. It was still under the positive list. I'm not sure what the positive list is, but if Richard wants to add anything to that.
Yeah, I answered the question, Frank, but the positive list being those industry sectors where it's not currently possible for 100% foreign ownership, and defence is one of them.
So what level is there allowed ownership? Is there any? I
think it depends very much on the particular regulatory authority, but in general, it could vary anything between 51% local ownership to something higher, perhaps up to 80%. It very much depends on the particular project and the authority that is governing the particular entity.
Frank,
Sure,
if you just allow me here to add, so unlike Dubai, as Richard just mentioned, there is a list of permitted activities in Dubai where foreigners can own up to 100%. In Qatar, it's not really the case, so there is no really a list that we can rely on. What we do in theory, in practice, is that every time we're asked by a client to check if those activities are permitted, we will go to the minister and they check with them. But out of our experience now for the past 3 years, almost, as I've mentioned earlier, almost all the activities are now allowed for foreign ownership, including the defense sector.
Sure, thanks. So there were two questions posed for Saudi Arabia. They're very related questions, so I'll pose them together. The first part being what is considered the best practice for dispute resolutions between a foreign party and a Saudi party? And secondly, is arbitration through the Dubai Chamber of Commerce considered a possibility?
Okay, thanks, Frank. Yeah, they are related, and I'll bundle them together because they do traverse the same sort of ground. The first thing I would say is that there's no one size fits all answer to the questions which have been posed. It really depends. That sounds like an answer given by a lawyer, and I apologize for that, but that really is the reality. In terms of Dubai Chamber of Commerce, arbitration awards, or arbitration processes, Saudi Arabia is a party to the New York Convention, and I believe Richard referred to that earlier on. So at least in theory, an arbitration award obtained in another convention country, which would include the UAE, ought be enforceable, and enforceable very, very quickly, without the merits of the matter being reconsidered in Saudi Arabia. Again, if I speak to my litigators, they tell me that's how it works or will work. All I can say is that in practice, I've rarely, if ever, seen an arbitration award obtained in another convention country being enforced straight away in Saudi Arabia. And part of the problem for that, or the big part of the problem for that, is certainly if you're talking about a non-Arabic country, there can be questions as to whether, in fact, the arbitration process itself accords with the requirements of Islamic Sharia. We tend to say, where people say, well, I want an arbitration, I like an arbitration process, and this is not necessarily just relevant to defense-related matters, want an arbitration process outside Saudi Arabia, what do you recommend? Then we would typically say, well, why don't you look at somewhere in the UAE? And, there are a number of forums in the UAE, arbitration forums in the UAE, where you award, because the UAE is partly to that convention. If you get the award, it should be enforceable in Saudi Arabia. The problem is however, potentially, is the tenders and procurements law, because what that says, and I've actually got the provisions in front of me at the moment, Article 154 of the regulations, arbitration shall be restricted to the contracts whose estimated value exceeds 100 million rial, so if we're talking about arbitration with a Saudi government entity, that's the first hoop we need to go through. It has to have a minimum value. And secondly, it can only be done where the other party of the contract is a foreign person. So if it is a non-Saudi entity versus a Saudi entity, at least in theory, it should work. However, and thirdly, I'm still far from confident that we can automatically agree to arbitration in the UAE or indeed anywhere outside Saudi Arabia without the approval of the minister. Quite frankly, you get different answers to the question whenever you raise it. And the view which I would put to clients is that the cautious approach would be to get that confirmed. And in practice, my experience has been that the Saudi government generally is very, very nervous about any arbitrations outside the country, and will resist any proposal that there should be an arbitration outside the country. Sometimes that is an outcome which is forced upon it by other slightly unusual, some might say nefarious means, that is ICSID. And those of you who are familiar with investment treaty litigation would know about ICSID, and that's something which might, as a sort of a stopgap, fail-safe measure, you want to look at. Best practice for dispute resolution in Saudi Arabia between a foreign party and Saudi company. As I say, in relation to a matter which relates to the regulation of determination of purely Saudi legal rights, I would say in Saudi Arabia, probably the Saudi Dispute Resolution Center in Riyadh, where I think certainly from what our arbitration guys tell me, there's a very high, they do perform at a good level. If the matter was subject to non-Saudi law, they can have non-Saudi arbitrators. But as I say, it depends on the dispute. There's no simple answer.
Thanks, Graham. One last question, which I'm not sure is really relevant for this discussion, but somebody asked whether there's any internship opportunities in Iraq for UK students. I would suggest that there's a section on our webpage called Join Us that covers things for new graduates, and perhaps there's something on students there. I don't know if Mohammed wants to say anything about that.
No, but I would say I would expect that Noor Al-Ataibi, she's a lawyer, and maybe she is interested to join us, and definitely she is welcome. And of course there is opportunity. And as you said, there is a website, or she can contact our HR, and definitely we shall do our support to her if she wants to have the opportunity to have internship in Iraq. And you are welcome in Iraq, Noor, as well. Thank you. So
I think that that's the end of the questions, and we're probably a little bit over time, and it could well be quite late for some people. So I'm going to pass over to Graham to send the closing remarks. But before I do that, I just wanted to thank Marwa Al-Morsi and Holly Cullis, who are both in our marketing team, who's put this webinar together and put a lot of hard work into it, and we're very appreciative for the support that they give us.
Thanks, Frank, and thanks everyone for your attention and attendance this afternoon. We do hope, speaking on behalf of all the Galtamimi participants, we do hope that you found this interesting, informative, and useful. As I said during my piece, it's not the A to Z of the subject, but hopefully we've given you a bit of a foretaste of the issues which can arise and do arise almost as night follows day in many cases, with investments of this kind in the different countries in the region in which we have offices, which is all the GCC, plus, as you will see from that table, which we've just put up on the screen, a few others as well. The reason why I put that, asked Holly to arrange for that table to be put up there is not to shock people, because I think most of the people who are on this webinar would be extremely familiar with the sort of interest which abounds around the region in defence projects. But the table does prompt a few observations. The first is, I don't know how reliable these estimates are, but they do come from what we regarded as being a reasonably reliable source. But nonetheless, you know, are they accurate? I just don't know. What I would say is that my suspicion is that at least in relation to Saudi Arabia, if anything, that would be an underestimate rather than an overestimate. Traditionally, I think the Saudi Arabian government has been rather coy about disclosing how much it spends on defence. I have no reason to believe it's any less coy these days. The other, I suppose, obvious comment is that even with the smaller countries, there is a very substantial appetite, if that's the right word, in defence. But what was particularly interesting to me, I suppose, bearing in mind that I think that Saudi Arabia at the last count I saw was probably about the 5th or 6th largest spender on defence in the world, is not so much the amounts being spent by the larger states, Saudi, UAE, but actually amounts being spent by the smaller states in the region. So, for instance, you look at Morocco, you look at Oman, really very substantial amounts being spent on defence in those countries, which, at least in relation to Morocco, took me a bit by surprise when I first saw it. Anyway, I don't have too much more to say, except that, as we said right at the outset, we are open to answering questions separately. If anyone is of a mind to send those questions to us, probably they should be directed, Frank, to Holly in the first instance, although I'm very happy to receive them direct, and probably the rest of the speakers likewise. And so,
our email addresses can be found on the Galtamimi website as well. So okay, it won't be hard to contact any of us.
All right. Without further ado, I'd just like to thank my fellow panel of speakers for their time, attention, and words of wisdom. And I hope you found this useful. And as I thank you for your attention, and thanks for the Galtamimi backroom staff for, as Frank said, for putting this all together. Bye for now.